Folks, Scott Sigrist. We're continuing our discussion of Hitler and the Germans by Eric Voegelin, and now we're going to discuss Chapter 6. We had just finished discussing his analysis of the Catholic Church during the Nazi period, um, and that was in the context of looking at different sectors of German society and how they responded or failed to respond to the evil of the Hitler regime, of Hitler in his rise to power, and the Hitler regime. Um, and he looked first at the universities, the intellectual leadership in the universities. Then he looked at the religious institutions, the Protestant and Catholic churches in Germany. And now he's looking, in Chapter 6, at the legal system. Um, and he starts where he often likes to start with the present, the constitutional system that had been established after the Nazi period, and and look at problems with it in relation to what went before. You notice he likes to do this. Start with the present and see how it relates to what came before, right? And with all these institutions, he's interested not just in how they handled Hitler and his system in the time when Hitler was active, but also the condition of those institutions here and now. Because he ultimately wants us to look at ourselves and to learn lessons for our own lives, right? So in Chapter 6, on the German legal system, he starts looking at this new constitution of the new federal republic that was established after the Nazi regime had fallen, right? The constitution is called the Basic Law, and Voegelin notes an incoherence in the principles and form of this new government that suggests certain problems with German thinking about things, their orientation about things, uh, continue, uh, remain a problem. Um, the new government is called a Rechtsstaat. It literally means right state. So, in the very name of the government, it suggests it's supposed to be based on justice, right? Um, the intended meaning, to quote Voegelin of Rechtsstaat, is that, quote, all laws in the society are derived from a norm acknowledged as the highest legitimate norm, that is, from constitutional norms, unquote. Voegelin raises the question, what is the notion of justice behind this? What makes a legal norm legitimate? And if the standard of justice is grasped, he thinks it has not been here, what form of government is most effective for upholding the standard? In other words, what is meant by Recht uh, and what is meant by Staat? Right? Uh, the question is, uh, what is the form of government, but also how does that form of government relate to justice? And confusion about this by the framers of the Basic Law are suggested in its the combination of this government of a hierarchical norm and separation of powers. Hierarchical norm is somebody at the top makes a decision and everybody carries out that order. Separation of powers suggests, by contrast, that power is separated into separate parts of the government, and those parts of government check each other's power, right? I'm trying to result in a more reasoned consensus and a moderation of power, right? These don't really go together. Uh, Hierarchy and separation of powers, and um, and so there's a problem both with lack of a clear idea of justice involved here, and then also with the form of government. The problems are fundamental, in other words. Um, so from here, Voegelin looks at the larger question of law and legal process. So, and he raises some key questions about the law. I'll quote with adjusting the quote slightly to bring in things that he says in the context but not in the quote. Quote, where do we find order? In other words, what is the basis or source of order? What are the contents of the law, and what do they command? What are the criteria of justice? In other words, the standards by which we determine whether something is just or not. How far may one allow the calculation of error to go in the application of the law? That is, so there is the law itself, and then there is the application of the law. And how do you figure out how to do that? These are fundamental questions about the law. Now, here Voegelin notes another problem that has to be considered, and that is an ideological problem. The ideology specifically of positivism. So, positivism is sometimes used in relation to science and sometimes in relation to law. The philosopher Thomas Hobbes is sometimes called the father of positivism because he expressed the essence of it, which is that in terms of legal positivism, the way you should understand law is not according to any kind of moral content, but in terms of power. That a law is made by the sovereign, right? And the legitimacy of the law, the authority of the law, comes from the fact that sovereign has power to enforce it. Right? The law in relation to justice is that it establishes the standard of justice. Justice is, for Hobbes, simply keeping your contracts, keeping the laws made by the sovereign, whoever it is in the supreme position in the government, right? So human law here is the standard of justice. There is no justice aside from the human law, and therefore there is no standard by which one could criticize a law as unjust. There can, by definition, be no such thing as an unjust law if the human law is the standard of justice, right? And so Voegelin wants to point out that there's an incompatibility between the idea of a substantive justice, a kind of justice you're trying to live up to, and taking man-made law as the ultimate standard. You have an equivalent notion in science. Scientific positivism is where the standard of being scientific is the facts without regard to value judgments, setting aside value judgments. And this is assuming that you can't have objective knowledge about, say, right and wrong. Right? So you leave value judgments out of your analysis of whatever phenomenon it is. Same thing happening in legal positivism. Leave out consideration of justice and morality. You just consider the dynamics of power in making and enforcing law. But if you want to have a Rechtsstaat based on justice, and this is supposed to imply something other than, say, what the Nazis had, positivism, which was the leading legal school of thought in Germany, is not going to cut it, right? I mean, the Nazis ruled through law. Oftentimes, they documented carefully everything they wanted to do, every order, and so forth. They passed laws, but the Germans wanted to say that the Nazi regime was unjust. How do they do that? By the positivistic reading, right? Voegelin himself had studied under a major positivist legal theorist named Hans Kelsen, and he ended up breaking with Kelsen publicly in a journal article, and and it was for this kind of reason. Positivistic understanding of law does not allow us to come to terms with the problem of an injustice like you saw with the Nazis. Right? So this ideology of positivism is 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 a real problem in thinking about this this new legal structure. But what about the application of the law? Um, should you apply it sort of mechanically, going strictly by the letter of the law, and saying, well, it says this, so we're going to do that regardless of the consequences, or or is it, which is the German, the way the German jurist had operated, basically, or should it be something like the Anglo-American tradition, where, based on independent reasoned judgment, a judge determines whether a particular application of the law will bring a just result or not. And this goes to the question of the what's called the spirit of the law. Right? There's the letter of the law, and if you go strictly by the book, right, that's following the letter of the law. But laws, the nature of laws is that they're general; they can't foresee every circumstance, and in applying the law, one has to decide whether a particular application makes sense in terms of the intent of the law. There are cases in which, if one goes by the strict letter of the law, it will have a result that was not intended by the makers of the law, right? And in that case, you have to think about how can I apply this law in a way that will result in a just outcome, right? So in the American system, you can talk about there's some connotation here with the originalist interpreters of the Constitution, originalist judges who want to look at the intent of the makers of the Constitution, and the so-called living constitutionalist judges. The living constitutionalist judges stress this point about trying to get a just outcome, and the originalists often try to push that question aside and just look at the intent of the framers, regardless of whatever you think about its justice. But the originalists themselves also will. I mean, when they're trying to apply the law, they will also do this same thing, where they think, does this application of the law make sense in terms of a just rendering of the intention of the law makers. In any case, so the point Voegelin brings out about this is that good people are indispensable. And it doesn't matter how well you set up the legal process, legal procedures, and so on. You've got to have people who understand justice and know how to apply it. And he concludes, the two greatest threats to legal order are, quote, if the men are corrupt and not capable of law and justice, or if they proffer some kind of ideology under justice, as with positivism, then of course one cannot have any legal order. So the problem is achieving justice, and you have to look at how that relates to the law and to the form of government. Well, dig a little deeper. What about the authority of the law? Why, in what sense, and to what degree do we owe obedience to the law? Well, what is the law's source of authority? Voegelin talks about the measures of what we could call, what is often called procedural justice. So you have written constitutions, formalized procedures, legislation by popular legislatures, and things like that, which is meant to bring government under the control of laws. Right? We call it the rule of law. So that even the people in government who pass and execute the law themselves have to comply with the law that they have made and enforce. Right? And this keeps the government in check. But Voegelin raises the question, what about the content of these laws? So, say you have everybody, the whole government, and everybody in the legal process and criminal law and civil law and so forth under the control of laws, but the laws themselves are unjust. So, for example, in the American context, the Jim Crow laws, the segregation laws, right? These were laws regulating the behavior of people. On a positivistic reading, this would be by definition just, right? The content of the law matters. So, how should we understand justice in the law? These questions, Voegelin notes, were traditionally handled in terms of natural law. Right, that was the term, natural law. It's a rich and varied tradition, but I want to single out three names, three people who help illustrate the issues. First, there was St. Augustine, who talked about an eternal law, which was the law by which God governs the universe, and the relation of that to human law. And he said that regarding human law, an unjust law is no law at all. What he meant by that was a law that is unjust really is not a law in the proper sense. It's just an imposition of the will of the ruler. Right. A law in the true sense must embody and enforce the higher law. And then 800 years later, St. Thomas Aquinas works this out more fully into his theory of natural law. He talks about four kinds of law. There's the eternal law of providence, what Augustine talked about, and then there's a natural law that can be recognized by reason and conscience. That you don't need to be a religious person to recognize that it's wrong to murder, for example. And then there's human law, and human law should be in conformity to natural law, and therefore to a higher law. Martin Luther King Jr. Gave perhaps the most striking example in the American context. In his letter from a Birmingham jail, he refers explicitly to Augustine and Aquinas in making these points. He had the letter from a Birmingham jail. He was in a Birmingham jail because he had violated a city ordinance requiring a permit for a protest, but the permit was designed to prevent black protesters from protesting in a place where it would make any difference. And so the law had an unjust intent. It was meant to prevent African Americans from expressing their free speech rights. All right. But he's writing this letter to white clergymen, preachers. He was a preacher, right? A minister, Baptist. And he wrote to the so-called moderate white clergy, who were generally supportive of his aims and of his efforts, but couldn't but told him they couldn't support him in this because uh, they couldn't see how he could justify violating the law. And in response to this, he mentions Augustine and Aquinas, among others, in saying that an unjust law is no law at all. And that, as uh, Thomas Aquinas said, uh, you are bound in conscience to obey just laws. You conversely have a duty to disobey unjust laws. Because our intention is not to um, our beef is not with the American system of laws. It's not with laws in general. It's with these particular unjust laws, right? So, in other words, he's appealing to a higher law. He's appealing over the man-made law to a higher law. And Voegelin's on board with all this, but he points out that this term, natural law, is not particularly helpful in that the nature of the law is not indicated by the term itself, right? So I mean, the question that these other thinkers tried to answer is not indicated by the term. So, in what sense natural? Are you saying? In what sense is the natural law natural, and in what sense is it law? Is it adequate to understand it as Locke does, for example, in terms of natural rights? The basic law, the German basic law, puts it in terms of inalienable human rights. It's very close to Locke's language, right? But then you can ask, and Voegelin asks, what is the basis of rights? How do we know we have rights? What's the foundation? And he points out that the basic law seems to suggest that it is human dignity. Right? And Martin Luther King talks about this too. He says, um, well, what is the substance of a just law and an unjust law? What's the criterion? Well, it says an unjust law is one that degrades the human personality, and a just law is one that upholds it. But then you can dig further and say, well, what is dignity? What makes human beings special, such that they should have dignity? And what does dignity mean? And Voegelin suggests that the root of it all is man's status as imago Dei, right? Made in the image of God. In other words, what he said earlier, more elaborately, in terms of having reason and spirit, right? We have these capacities to be oriented towards the divine and to participate in the divine, right? So Plato talked about it in terms of nous, which is an orientation towards the divine. We looked at how he symbolized that in the cave image with the myth of the puppet player, the golden cord, and then of course the term image of God comes from the Bible, and so and Voegelin pointed out how the Christian term faith means roughly the same thing as excuse me, as the Greek term philosophy, philia plus sophia, the love of wisdom, relates that to the Christian faith, hope, and love. All of this relates to that man as a creature that has some kind of connection with God, that manifests in some sense the nature of God. The way Thomas put this, St. Thomas Aquinas, is that we all have the divine imprint. We see this, for example, he suggests in our inclinations. I'll come back to that momentarily. So, so Voegelin says, okay, it's good to have a constitutional system, a form of government. Law is critical. Having the rule of law is critical. But what about justice? How does that fit in? Is it enough for justice to have certain procedures in place, um, or is there something more than that? And there's something more that he's talking about. He he um, he also uses the term, excuse me, moral substance. It's a substantive thing, right? It's based in the kind of experiential grounding that we just mentioned in terms of reason and spirit, right? Or reason and faith. Um, so in the end, even a well-conceived constitution, much less a poorly conceived one, like the Basic Law, uh, is not enough to save a corrupted society. My throat's getting a little bare here. So I'll quote Voegelin here. So what matters is the moral condition of the society, and not this legal construction, which really only makes sense on the presupposition that the society is morally intact and that it does not simply throw it on the scrap heap the next day. Unquote. In other words, um, say you have the perfect constitution in terms of the form of government and the legal process that's set up and everything. It presupposes for it to work that um, people will play by the rules, right? If they're not willing to play by the rules, if the people making the laws, executing the laws, people putting those people in power, say if you have elections and so forth, if they don't abide by the rules, then the system can't work, right? So when Kant says, going back to one of our earlier thinkers, when Immanuel Kant says, as he does in one place, that you could devise a system, if you devised it right, it would work even for a nation of devils. This is simply not true, because a nation, a devil would not be willing to follow the rules. Then you've got, you could try the approach that Hobbes took, which he did sort of assume human beings are like devils, right? But he said if you create this Leviathan, a government who can crush anyone who disobeys the law, then you can make them behave, right? But then the obvious question, we talked about this kind of stuff earlier, well, what's to keep the sovereign himself, the ruler with absolute power, from using that power against us? I mean, if he's a devil too, right? So, um, well, the point is that it ultimately falls apart without some decency in the people and the rulers, right? My favorite quote about this is from one of the American founders, one of the so-called forgotten founders, John Witherspoon, who was James Madison's mentor at Princeton. And he put it this way, quote, "Nothing is more certain than that a general profligacy and corruption of manners make a people ripe for destruction. A good form of government may hold the rotten materials together for some time. Beyond a certain pitch, even the best constitution will be ineffectual, and slavery must ensue." Unquote. The rotten materials here are the people, right? He's saying, even the best constitution can only hold things together for so long if the people are rotten. And Madison said something similar to this. I mean, Madison talked about the separation of powers, checks and balances in Federalist 51 in terms of auxiliary precautions. He said, no doubt the greatest check on government is I can't remember what the term is a dependence upon the people, by which he means the people put the government personnel in power, and their jobs depending on the people is the first check. The second check is auxiliary precautions. And why is that needed? That's needed because men are no angels, he said. But in another place, in the Federalist Papers, Hamilton mentions that this need for character, for a certain level of virtue. There he says, this is Federalist 55, there Madison says, as there is a certain quality in human nature that calls for a certain level of distrust and circumspection, so there are other qualities uh, that call for a certain amount of esteem. In other words, human beings are sort of a mix of good and bad, right? We're capable of evil, but also capable of good. And he says a republican form of government, in other words, a government elected by the people, assumes these good qualities in a higher degree than any other. Right? But again, he's saying that everything depends on the virtue of the people in the end. A good form of government can hold things together when the people are not as virtuous as they should be, not as involved as they should be, right? Not as informed as they should be, and so forth. But in the long run, there has to be something better than a rotten people. Well, bringing all this down to brass tacks, Voegelin takes up the issue of the war crime trials, right? These trials of Nazi war criminals that he opened up the whole lectures discussing as uh, as a kind of gateway into pointing out that Germans are having trouble coming to grips with what happened and how to respond to it, right? And so Voegelin takes up this question of the guilt of war criminals, and in particular, the question of the guilt of those who gave the orders and then those who followed the orders, right? Everybody agreed that those who gave the orders were guilty. Um, you know, the people who established the final solution, Hitler, his top men, and so forth, they were obviously guilty for giving the orders. But a lot of the people on trial for war crimes were giving as their justification that they were only following orders, right? Orders had been passed down, and we were only following orders. And the court determined that this was not a sufficient defense. That you should have known. There's no way you could not have known that murder is wrong. It's simply not an excuse that you were following orders. And Voegelin pushes down to the root of the problem here. He says the root of this defense, I was only following orders, is a kind of willful blindness. I don't think that's the term he uses, but it's what he means. A willful blindness that comes with the second reality. So the second reality is the term he's given for the ideology, right? The system. Hitler's created this system, this view of the world. People are living according to it, right, in the second reality. And soldiers tell themselves, if there's any hesitation, I'm only carrying out the historical imperative, right? Of I'm doing what the Fuhrer, the leader with a capital L, says, and I'm following the historical imperative of the system that I bought into with Hitler's rule. But this is not enough. It's not an excuse that you have this ideology. And I'll give you an illustration I like to give. Imagine there are some Nazi soldiers, and they've rounded up some Jews, and they're going to shoot them. They've dug a big pit, mass grave. They've lined them up along the side of the pit, and they're going to shoot them. Right. And there's a few soldiers given this task of shooting them. So imagine the one of these soldiers walking up and he's about to shoot this little old lady who reminds him of his grandmother. And for just a moment, he hesitates because this looks like my grandmother. But he says to himself, I've got to act according to the historical imperative, right? So I'm going to ignore that. I'm going to put it out of my mind. Now that putting it out of your mind is a critical step. That is a deliberate move. In other words, it's an exercise of free will. It comes to your consciousness. This is a person like my grandmother, but you shut that out. That is willful blindness. You refuse to look at it, right? That is a choice, whether you're going to look at it. It's comparable to the way Hitler reads, right? He reads a book and he just ignores, pretends it's not there, the other stuff that doesn't fit his second reality, his ideology. He's not going to look at it. So Voegelin, so he's trying to say, bringing it down to brass tacks, what is the responsibility of each of the people for themselves here, right? And I think he takes it for granted that there are different levels of guilt, right? And the people who give the orders are the most guilty, and that there are, various, mitigating circumstances and degrees to which people may be guilty, but ultimately, for the society to come to terms with the evil of what happened, they've got to come to terms with what people did and their responsibility for it. And not only that, what people now are doing, thinking, how they're acting in relation to that. That is their responsibility, right? And that's why these war crime trials matter, and the way people are thinking and talking about the war criminals matter, right? The last thing that I'll point out is, in relation to this guilt question, is how Voegelin talks about the complicity of authorities not directly involved. Okay, so what if you weren't carrying out the orders, but you continued to do things that were necessary for the regime to do these things, right? Judges, generals, professors, etc. How should we look at them? And Voegelin brings in this English legal concept called accessories after the fact, right? So a classic example here is somebody driving a getaway car, right? You've got a car, you're going to rob a bank. There's several robbers in the car, but most of them are going to go inside, but one person at least has to stay at the wheel and have the car ready so that when they run out, you can drive them off, right? And let's say one of the robbers shoots somebody. And they come back, they get in the car, he drives them away. What's the guilt of the driver? He hasn't actually committed the robbery itself. He certainly has not shot anybody. But a court would say he has participated in an activity that was likely to result in such things. I mean, of course, he knew that there was going to be an effort to rob the bank, and he knew, say they go in with guns and stuff like that, he knew that there's possibility that somebody gets shot, right? So even though he doesn't have the same level of guilt as the guy who shot the person, and maybe not quite the level of guilt as the people who actually performed the robbery, though closer to that, nevertheless, he shares in the guilt, right? And so authorities in the German regime doing things that they knew would facilitate the carrying out of these crimes even though they weren't directly involved with the criminal action. Uh, they were accessories after the fact. Right. And he thinks this accessories after the fact continues to some degree in Voegelin's own time and here in the 60s, where, where people are not, authorities in particular, are not the music. Right. There was something else I was going to add on this. Yeah, I know what I was going to add is bring it to the American context, to us, in terms of the American regime, in terms of the American Constitution, in terms of this questions of moral substance and justice, and we can ask ourselves these same kinds of questions. The Constitution, according to the founders' own theory, as stated in the Declaration of Independence, is supposed to uphold rights, right? And that means justice. In the Declaration, it says that the purpose of government is to uphold the inalienable rights that are mentioned in the most famous section, and that and therefore the purpose of any government, and of course, therefore, the U.S. Constitution, the government set up by that, the purpose of that is to fulfill justice. And it does say that actually in the preamble of the Constitution, justice is listed as one of the ends of the government established, or that the Constitution is meant to uphold, right? But we can ask ourselves also, in terms of the laws that we see passed pursuant to the Constitution, are they, not only are they procedurally in line with the Constitution, but are they just? Are they upholding what the Constitution was meant to uphold, right? And are we the quality of people? Do we have the character? Do we have the moral substance to recognize what's good and bad and what the government is doing, the laws they're passing, the way that they're being executed, and so forth? So we have the capacity to see that and to hold the government accountable. Because if we're corrupt, then the people we elect are probably a good chance they're going to be corrupt, right? And what is our responsibility? What is your responsibility, your and mine, as individual citizens for our country? Is it just to follow the news? Is it just to vote? Or is there not, in fact, a much more demanding task to take care of our own responsibilities to society, to set our own house in order, and to engage in making sure that our society continues to, or better, upholds justice? Okay, that's enough. I'll talk to you about Chapter 7 next time. Chapter 7 is going to bring us to some of Voegelin's larger conclusions. And Chapter 8 is going to talk about the way out of the abyss that he's been talking about. All right, I'll leave it there. I'll talk to you next time.